Okay. Counsel, when you're ready, Ms. Norris.
Good morning, Your Honors. May it please the court. My name is Kristen Norris, and together with Stuart Markman of Kynes, Markman, and Fellman, we represent the plaintiff and appellant Lawrence Brawley. I'd like to reserve 5 minutes for rebuttal, please.
Okay.
This is an appeal of a summary judgment in favor of Tampa General Hospital and against plaintiff Lawrence Brawley in a medical negligence case. Mr. Brawley went to Tampa General Hospital for outpatient surgery for back pain, the implantation of a spinal cord stimulator, and he left a paraplegic needing constant care. What he learned after the surgery was something that TGH knew all along, that the surgeon who performed it had actually rendered 3 prior patients a paraplegic, and yet nothing had been done to revoke his privileges. Mr. Brawley also learned that his injury could have been easily prevented by a checklist that would have required pre-surgery imaging that other hospitals require. This was not a summary judgment case. The trial court committed at least 3 legal errors in granting summary judgment. It resolved summary judgment on the negligent retention claim that TGH never challenged. It resolved factual disputes on the hospital's negligence on the remaining claims, and it overlooked the evidence that Mr. Brawley presented in support of them. And it did not require TGH to meet its burden on summary judgment, but rather shifted the burden to Mr. Brawley to try to prove all of his claims. The judgment should be reversed. Our brief has covered the 3 different counts on summary judgment, but I want to focus first on Mr. Brawley's negligence claims. Mr. Brawley's complaint alleged 4 separate bases for TGH's negligence. And the motion for summary judgment challenged only one, the one related to surgical services and risk management. For every other claim that Mr. Brawley alleged, TGH's motion made no summary judgment argument at all. And despite that, the court proceeded to allow TGH to expand its arguments. Because the motion itself was facially sufficient, it should have been denied on its face, and that alone should require reversal. But instead of denying the motion, the court permitted TGH to develop some new arguments. None of those support summary judgment either. I want to start with the negligence claim for negligent retention. TGH never raised a challenge to that claim, either in its motion, in its reply, or in its summary judgment arguments at the 2 hearings held.
I have a question in that regard. Yeah. Didn't Brawley admit that Smith was properly credentialed and properly qualified to do the surgery? And the court was careful in saying, I find no negligence on TGH, and it was up to the jury as to the surgeon himself whether he was negligent. So the summary judgment only pertained to TGH.
Correct. The summary judgment only, the doctor had actually been, had the case against the doctor been resolved before these motions were heard. I don't think the court understood that, because at the end of the motion, she kind of referred to, oh, well, you can raise all this with a doctor, but that's not the case. This is a direct claim against TGH as to retaining Dr. Smith. Now, on whether he should have been credentialed in the first place and retained, that yes, they pointed to one interrogatory. They never said that this related to the retention claim, by the way. This came up in the credentialing to begin with claim. But they said there's this one interrogatory, and Mr. Brawley says that he doesn't contend the doctor was not, quote, qualified to perform the procedure. But Mr. Brawley's claim was not that he didn't have a medical license or he wasn't board certified. It was that he was negligently credentialed despite and retained, despite the fact that he had shown his incompetence.
So the question becomes, he did a surgery, didn't order a preoperative MRI, and the hospital's position was, hey, if we do that, then we are controlling the doctor. We're not allowed to do that. And he went into a space that was too narrow, and that caused a problem because specifically this gentleman had a narrow spinal canal that the needle apparently wouldn't fit in without creating a problem, and that is not a common condition. So comparing that to the other 3, we don't know anything about those other 3, if it was the same exact fact pattern or totally different.
I agree, we don't know about those other 3. And on the negligent retention claim, that's because they never said, they never argued that the negligent retention claim wasn't supported by undisputed evidence, or presented undisputed evidence that they were not negligent in retaining him after those incidents. Had their motion said, we were not negligent in retaining him. We looked in these prior incidents, or had they offered any expert testimony on that, then I think we could have a discussion over whether there was a dispute of fact. But it's undisputed by TGH in their answer brief. They did not raise the negligent retention claim at all. They did raise the surgical services, and I'm going to get to that point also, because I think that was another theory of negligence. But as to negligent retention, there is no argument made. They didn't ask Brawley to, prove disputed fact on that, and they didn't make their initial showing that there were no disputes of fact and that they were not negligent. So as to the negligent retention claim, there really was no argument that there wasn't a duty. That duty is in section 766.110, which requires the hospitals to reasonably review the doctors it allows to perform surgeries and to act on reports of adverse medical incidents. And again, TGH presented no argument in support of its claim that there was undisputed facts on this. So the evidence that we do have in the record anecdotally is that there was a reason to talk to Dr. Smith, and that they had not talked to Dr. Smith even after they were brought into a lawsuit to defend against the claim for similar injuries. The expert testimony that Mr. Brawley filed in support of the other claims that TGH did challenge also pointed out that they did not have appropriate processes for reviewing doctors who were already credentialed. So in this respect, the judge resolved the claim that was never challenged at all. I want to switch to the negligent credentialing claim. Again, I think it's, Your Honor has kind of noted in your question, these kind of all relate to each other. They're all arising out of 766.110. They're all arising out of, what the hospital is required to do in order to ensure that the services it provides and the doctors it permits to perform the surgeries are reasonably safe. And so as to negligent credentialing, TGH made one argument, and this was actually in its reply, not in its motion, that it contended that it was not negligent in credentialing Dr. Smith. So Mr. Brawley responded to the reply, and he presented expert testimony that TGH fell below the standard of care in credentialing because it credentialed Dr. Smith for a procedure without having input from a doctor who knew how to perform that procedure. The only evidence that TGH presented in reply was, well, first it presented argument of counsel that the counsel didn't believe that was required, but that's not evidence. And then it presented this interrogatory answer. I want to talk about that interrogatory answer a little bit more.
Can I ask you a question? I don't like to interrupt, but you have 4 issues on appeal, right? Am I right? Reading the brief, you have 4 issues on appeal. Which of those 4 issues do you say is the equivalent of your argument today, negligent retention? Which argument, which issue does that come under?
The negligent retention is part of issue 1 on the resolution of the negligence count. So the resolution of the negligence count, the court resolved all of the allegations of negligence, which included at least 3, 4, maybe depending on how you divvy them up, subsets of theories of negligence. So this is all in issue 1 of our brief.
I got you.
Yeah, and the way it lays out may be confusing because we were trying to follow the process by which the judge held these hearings over a series, and different arguments got raised. And
well, the judge waited until discovery was complete because that was one of the objections made at the initial hearing, correct?
There was outstanding discovery on the adverse incidents, and so that she didn't wait on that. There was also some outstanding discovery on the joint venture. We've noted and argued the outstanding evidence on the adverse incidents in our brief. The joint venture, we didn't argue that, but that also was granted over objection that there was outstanding discovery. So coming back to the interrogatory on the negligent credentialing claim, again, Mr. Brawley's answer was he didn't contend that Dr. Smith wasn't qualified. And he wasn't challenging, in fact, medical degree, these kinds of base qualifications. If there was any confusion about what he meant by that same month, Mr. Brawley filed a response to expert interrogatories, and the expert interrogatories included the expert's opinion that TGH had negligently credentialed Dr. Smith because it didn't have an equally experienced doctor to participate in that process. So
What do you have any cases that especially support your negligent credentialing, that the summary judgment evidence supports negligent credentialing under, in this case, under 766.110 subsection 1?
Mm-hmm. So I don't know that I have the cases in hand, but the case law recognizes that there is a claim for negligent credentialing under section 766.110. And what this comes down to, and this is something that the cases generally explain also, is that there's the 766.110 imposes the duty. You have a duty to be reasonable in how you credential your doctors. How you, whether
What was unreasonable here, and are there cases that support that unreasonableness?
Right. So what happens here, and the cases explain this, is that to decide whether or not a hospital or a doctor is negligent, we need to know what reasonable hospitals do. And the way we know what reasonable hospitals do is we look to experts to tell us what that standard of care is. And the case law is clear that once you get to the duties in the statute, and now you need to know, what do reasonable hospitals do? How do we measure that? How do we decide what's reasonable? We look at the expert testimony. So here, the unrefuted expert testimony is that was required by reasonable hospitals. TGH could have tried, I mean, it wouldn't have helped them on summary judgment, but they can present, I'm sorry.
What was required that they didn't do?
The evidence was that they credentialed doctors on a procedure by procedure basis. And so the expert testified that in order to credential a doctor for a procedure, you have to have the input, whether it be a member of your staff or you ask another doctor just for input on a contract basis, to know what that procedure entails and to review the process by which you decide whether this physician is competent to perform it.
And you're saying that duty exists independent in this case of the specific contention that he should have ordered a pre-op MRI? Correct.
The case law recognizes the retention duty as a separate duty from the risk management protocols. So this is a duty that's specifically in the statute. And the question of whether they breach that duty comes down typically to a battle of the experts, a question of fact on, well, should a reasonable hospital, have this credentialing process?
I just want to, I'm sorry, I want to interrupt for a minute because I keep hearing questions about what your expert said, but
Right.
This was Tampa General's motion, correct?
It was Tampa General's motion, correct?
Okay, what did Tampa General's motion say with respect to credentialing?
Right.
Did they contest whether there was a duty, number one, and number two, did they offer any testimony as to expert testimony as to what a reasonable hospital would do in terms of credentialing?
Correct. They did not. So what this was actually the issue raised in the reply. They disputed the idea with argument that there should be the requirement of a similar doctor on staff, but they did not offer any expert testimony on that point. There is.
So that was just argument of counsel.
Right. That was argument of
So
counsel.
we don't have conflicting expert testimony. We only have the expert testimony on behalf of Mr. Brawley.
Correct. Correct. They did not offer expert testimony on the hospital's negligence. I would say on any of the claims, the only potential, I think there was the doctor who was, Dr. Smith may have said, well, I don't think TGH did anything wrong generally, but they offered nothing on what a reasonable hospital does on credentialing, nothing on what a reasonable hospital does on the risk management protocols for surgeries, nothing on, that their retention, credentialing, or risk management processes were within the typical standard of care for a reasonable hospital, like hospital. So really their argument on Their only other argument on the credentialing was the interrogatory. And as I've explained, there was also the interrogatory from Mr. Brawley explaining that, he had an expert who was going to testify about this negligent credentialing and why. And then of course there was a deposition of the expert that did that. So at best, this interrogatory lay answer by Mr. Brawley, maybe, ambiguous as to what he meant, and a question of fact in that he had in fact asserted negligence through the expert testimony. I want to get to the surgical services. I think, Judge Volante's asked some questions on this too. And this is another area that may interest Judge Atkinson's or implicate Judge Atkinson's question. So again, Tampa General's motion says, and this was one argument they did raise in the motion itself, we don't have a duty to provide safe surgical services like Mr. Brawley alleges. Okay, so that duty, as it was alleged in the complaint, is directly taken from section 766.110. The statute imposes duties that it says expressly include, but are not limited to, the duty to reasonably develop risk management processes. And it refers to chapters 395, and particularly a duty to develop and implement protocols to ensure that surgeries can be done in a safe manner. And the 766.110 is specifically a statutory cause of action. It says, if you do not do this reasonably, you are liable. The hospital is liable directly to the patient. The argument that TGA presented was basically, again, a standard of care argument. Mr. Brawley presented expert testimony that reasonable hospitals look at surgeries like this and have a checklist. And because of the requirement that surgeries need to be performed reasonably safely, they would require the doctor to have a pre-surgery MRI. In response, TGA said, you can't do that. It was an argument of counsel. You can't do that because you'd be infringing on the doctor's independent medical judgment. That, number one, is refuted by the evidence, including the evidence from TGH's own expert, who testified that yes, in fact, hospitals can and do institute protocols that require certain things before surgery and could, in fact, require pre-surgery imaging. It was refuted by the testimony of Mr. Brawley's expert that reasonable hospitals do this, but it's also inconsistent with the language of the statute, which requires the hospital to have protocols like this.
Ms. Norris, I'm sorry to interrupt. Please finish your answer, but you are at the end of your time, if you want to say for rebuttal.
I will reserve the rest of my time and rest on my briefs for the other two counts, the joint venture and the breach of contract, and I appreciate your time.
Thank you. Counsel, when you're ready.
Good morning, Your Honors. May it please the court. My name is Amy Dilday from McCumber Daniels, and I represent Tampa General Hospital. The trial court correctly entered summary judgment on the breach of contract claim because the existence and interpretation of contracts is a matter of law, and TGH did not contract to provide emergency treatment.
Can I just interrupt you?
Yes.
I'm sorry to, jump into your argument right away, but I don't think we heard any argument initially on the breach of contract claim. And if you want to address that, that's fine. But I would really like you to make sure you save some time to address the argument that was just made on the negligence claim.
Absolutely, Your Honor. And I'll start by trying to clear up a few questions, because it was a little confusing about what Brawley was actually alleging in his complaint and what was dealt with in the summary judgment. So let's just start with Brawley's original allegation.
But let's start, and that's fine, but also we have to look at what was argued in your motion too.
Yes.
Okay.
Yes, absolutely. And I'm leading into that. I just want to point out that there were 5 ABCD. That makes 4 subsections under his risk management claim. The first one did deal with retention, failure to properly retain Dr. Smith. That was subsection A. I'm going to skip to subsection C because that's what got argued in the trial court. That's what was dealt with in all the motions and all of the arguments, with one written exception, which I will also address. Subsection C was the failure to provide well-organized surgical services that met the standard of care, and the failure to privilege Smith in accordance with the competency. So that's how the separation between retention, which was actually in subsection A that never got dealt with in the trial court, versus privileging, which is in subsection C, and they threw in the word credentialing with that privileging. That's where the separation came in the way that the allegation was alleged, and then the way the motions got argued. Now, in TGH's reply response, which Brawley admitted in the trial court was its actual motion for summary judgment, TGH addressed the duty to provide under subsection C the well-organized surgical services and the failing to privilege Smith. And the reason that happened is because all of the evidence that had been developed, all the evidence that had came up, and even when Brawley filed his original response to TGH's original motion, that was the only issue that Brawley said there are issues of fact on, and we are contesting summary judgment on that. So in the end, let me jump to the end. When the court found summary judgment on count 5, we concede that only subsection C was dealt with head on in the court. Brawley did write in its motions that they were only dealing with subsection C, but at the hearing, when Tampa General said, well, once that summary judgment is in, that pretty much disposes of all counts against TGH, Brawley did not disagree. He agreed that there's final summary judgment in this case. He didn't bring to the court's attention one more time while it was making the error at the time of the alleged error, oh, wait, we still have a negligent retention claim out there. They did not mention that during the hearing at all. It just was never developed or argued in the trial court. So that's where it was. Brawley informed the court he intended to appeal, but he never contended that the reason he was going to appeal was because there was an unresolved issue on retention. Rather, he just conceded, in the trial court, the case is over. So he didn't file a motion for reconsideration or rehearing. And so as to those outstanding issues, he just never really brought the attention of the court to the fact that they were there. And I'm not saying he didn't say in his writing in just one sentence in his written motions that this is only dealing with subsection C, because Brawley did say that. But that's what happened in the trial court. There was no, wait a minute, court, you can't do that. And yet here we are on appeal. And the main issue that Brawley—
Well, how many times do they have to say it?
Well, I would agree that if they say it in a written motion, certainly I have relied on written motions that don't get brought up in hearing. But to argue right now, retention or not retention, I'm just letting the court know that's the facts, and that's how it all played out. So that's where the retention claim was. Brawley otherwise just dealt with the privileging and dealt with the credentialing. TGH submitted evidence that Dr. Smith was privileged to perform the surgery through his own testimony and through the delineation of privileges form. To your question prior, Judge Kelly, I will concede that we did not present expert testimony saying this is the way credentialing should happen. However, to Judge Volante's comments, Mr. Brawley did represent in his answers to interrogatories that he was not contending that Dr. Smith was not qualified to perform the surgery. And I think TGH had a right to rely on that representation.
I want to ask you about that, because this whole argument about relying on that interrogatory for what you're relying on it for bothers me. I'll be candid with you. It seems disingenuous to me, not intentionally disingenuous, but it bothers me. If the question had been, the answer had been, yes, I think my doctor was unqualified, would you then concede, oh yes, he was unqualified and we improperly credentialed him? Would you consider that answer determinative on that question?
Your Honor, the question was not whether Brawley himself thought that Dr. Smith could or couldn't do the surgery. I think it has to be assumed that he entrusted
Well,
himself.
let's just say he answered that the doctor wasn't qualified. Would you
Well,
still
if-
be relying on that answer?
We would rely on that as Brawley's position. And that's what
Right, but would you let Brawley assert that as a basis for concluding that Tampa General didn't properly credential him?
No, Your Honor, of course we wouldn't, because it's
But
his burden of
you're
proof.
using, am I right that you're using it? You're using it that way because he answered that he wasn't contending, that he wasn't qualified.
Your Honor, the reason that we put out the interrogatories in the first place is to try to narrow the issues. It's to try to,
Right, you're not
narrow
trying to get
down.
an expert opinion from the plaintiff on the doctor's credentialing. You're trying to narrow the issues in the litigation. And then you have expert interrogatories that give you the information on what their experts are going to say about the credentialing claim.
Your Honor,
I mean,
I'm sorry.
I'm sorry, I have a real problem. I don't mean to beat you up on this, but I want to give you an opportunity. I want you to know my concern on this because I am finding it difficult to agree that answer carries the way that you want to give to it. And I want you to know that so you can give me your best shot on it.
I appreciate that, Your Honor. And my best shot literally is just that we have a right to rely on the plaintiff telling us what they think we did wrong. And when the plaintiff said, well, we don't think that qualification was a problem, and then that honestly was the basis for the trial court's judgment on that. The trial court found that answer removed the challenge to Dr. Smith's credentialing, and that in the trial court settled the issue. So to the extent that this court thinks that was error, then that's
well. Let me ask you. Let me follow up then. So the trial court relied on that, but wasn't there? Am I remembering correctly that that Brawley offered some expert testimony that was contrary to that? Is that correct? That said this wasn't proper credentialing?
So Brawley's testimony as far as credentialing was that Dr. Boyko was the expert. He just said that Dr. Smith didn't have the privileges at all. That testimony was refuted by the 2014 delineation of privileges form. And that form showed that in 2014, the Department of Neurology of Neurosurgery of Tampa General, the department chief certified the form that he reviewed it. He reviewed the requested privileges. He reviewed supporting documentation. He reviewed the experience and the clinical competence of the physician himself, and he provided those privileges. And the form did, in fact, demonstrate that one of those privileges included the surgery. So Dr. Boyko's testimony was just that he didn't even have them. It's not on the form, but that was refuted by the black and white paper of the form itself. Secondly, Dr. Boyko admitted that he had no way to know one way or the other of Smith's competence, or that he just said generally and conclusory, well, TGH credentialing process is a mess, basically was what he said. So to say that actually Brawley put in—
Did he offer any elaboration on that? Or he just said it was a mess?
He said it's a mess, and he said he basically said, and again, this is a conclusory opinion, that if there is no other physician at the hospital that does this surgery, then there's no way that they could have properly credentialed him to do this, because there's no one there that does it, so they don't know. But that doesn't make common sense, Your Honor, because there's tons of—
Well, let me just interrupt you, because you answered my question, and now I'm wondering, you have the trial court relying on Mr. Brawley's interrogatory answer, and now you have all this expert opinion that you've just discussed that conflicts with that. And I understand that you're taking issue with the expert, it's against common sense, but doesn't that create a fact issue?
Well, it doesn't, Your Honor, if it's conclusory opinions, because expert opinions that are conclusory are inadmissible anyway. So no, I don't believe it does create a competent substantial issue, and not on the privileging issue, but the trial court specifically found Dr. Boyko's standard of care opinion was not supported by any medical authority or statute. And the same is true about his credentialing opinion.
Does that sound to you like he's weighing the testimony on a summary judgment?
No, Your Honor. This would be more along the lines of, and there was no official Daubert challenge to it, but this would be more along the lines of what the trial court needs to do is decide whether it's admissible evidence, because summary judgment has to be supported by admissible evidence. And I would say even the evidence that the non-movement party puts in to say, oh no, you can't do summary judgment, we refute it, it still has to be admissible. If it's not admissible,
Is that the Coachman argument that we're sort of reading the tea leaves or inferring that it was admissible? Or is there any suggestion at all that was the trial court's rationale if this was not admissible, therefore it didn't create a fact issue?
Again, Your Honor, there was for the standard of care. Now, I'm pointing out, just to be perfectly candid, that comment was not as to the qualification and privilege argument, but as to the standard of care argument, how Dr. Boyko formed his opinion that there had to be a preoperative MRI and that TGH had to have this checklist to require preoperative MRI was because he relied on plaintiff's neurosurgical expert, Dr. Macon's opinion that it is the standard of care for neurosurgeons to order an MRI. That was his sole basis for saying, since Dr. Macon says neurosurgeons standard of care requires an MRI, MRIs, the hospital should require it. That was the sole basis. He had no authority. He had no statute. He had no medical literature that said that. Boyko himself admitted that ordering an MRI was a clinical decision. He admitted that if the neurosurgery department looked at it and decided that the TGH's neurosurgery department, if they looked at it and decided, well, we don't think that it's necessary, he would not be competent to testify that that was an incorrect decision. So literally he had no qualifications to say one way or another whether this clinical decision that was the neurosurgery standard of care should be transferred onto TGH. And I want to go into the statutes and talk about them as well really quickly. Section 395.00212 defines a hospital as being required to make clinical laboratory services, diagnostic x-ray services, and treatment facilities available for surgery. There's no question that an MRI was available for Dr. Smith's use if he chose to do so. TGH fulfilled that statutory requirement. TGH also agrees that section 766.1101 does create duties for hospitals. But even with 766.110's reference to section 395.0197, it does not create a cause of action for whatever responsibility the plaintiff wants to allege. Chapter 395 governs hospital licensing, and section 395.017 does not include a private cause of action independent of section 766.110 for breach. It's solely a licensing statute. Therefore, if a plaintiff wants to bring a claim under section 766.1110, it must be limited to those duties that are specifically outlined in section 766.1110. Otherwise, just like the trial court noted, hindsight's going to become the standard of care if we go into 395 and start making those decisions. The obligation under chapter 395 is just that the program is in place. It doesn't require specific checklists. It doesn't require the hospitals to practice medicine in any way or provide treatment in any way whatsoever. Even if chapter 766.110's private cause of action expands to section 395.017, as the trial court noted, those functions in chapter 395 are administrative. Again, it's a licensing statute. it doesn't go to medical diagnosis and treatment. Again, we for the arguments made in our brief, we submit that the breach of contract claim was properly decided under summary judgment. We submit that the joint venture claim was properly decided under summary judgment because there was no evidence of certain elements of the joint venture. And this court in Brown versus Snellgrove has affirmed summary judgment on joint venture when elements did not exist. If there are no further questions, Tampa General would just request that this court affirm summary
I
judgment.
was going to ask about the interrogatory answer again. I just want to clarify, and maybe there's multiple layers of your argument. The first being, and I'm putting words in your mouth, then I could be completely off base, but you're not relying on that as evidence, which would ostensibly create or presumably create a factor. So you're relying on it on the master of his own complaint, the plaintiff having narrowed the issue in his complaint. And that's the first layer of your argument, correct?
Oh, that's correct, Your Honor. And that's exactly what the trial court found. The trial court basically found that Brawley took that off the table by saying he wasn't going to contend that Dr. Smith was not competent. So
you're not contending that was evidence, or that was summary judgment evidence, but merely a narrowing, essentially a tacit amendment of the complaint itself.
yes, that's the issue. I would also like to just, in conclusion, ask that is this trial court finds that other issues under the risk management claim need to be remanded to the trial court for resolution, that it would at least affirm paragraph 65, subsection C, on the failure to provide organized surgical services and failure to privilege Dr. Smith. Thank you, Your Honors.
Thank you. Ms. Norris, when you're ready.
Okay, thank you. I'll try to hit some of these points. You covered a lot of ground, so try to hit them. So there's basically a concession that the retention claim was really never raised, argued, vetted at all, and yet resolved. And the only real argument against that is this waiver argument that for some reason, this was not preserved. And that argument rests effectively on this argument that after the trial judge ruled that she was granting summary judgment on negligence, Mr. Brawley had to reassert something he'd said 4 times. And I just want to be clear that it wasn't just in the response to the initial motion. The motion TGH filed quoted the 4 theories of negligence. Brawley's response to that first motion, the written response, quoted the 4 theories of negligence and said they've only attacked 1, and it would be error for the court to grant summary judgment on grounds not raised with specificity. At the first hearing, and in light of the new reply that TGH had filed, Brawley reiterated these same concerns. You can't allow them to expand the summary judgment, but you also cannot rule on a matter that has not been stated with particularity. He explained that it was effectively becoming an ambush and the motion should be denied. The court continued the hearing rather than denying the motion at that point, said it was going to consider TGH's reply, so he filed a response to the reply. The response attached his original one in total, but also said it was reiterating those allegations. And then it said again, it quoted the 4 claims, and it cited the law that says you can't grant summary judgment on a motion that doesn't state a ground with particularity. And at the last hearing, he tried to address the arguments that TGH made, but at record 2387, he referred the court to the complaint, and he explained that there were various breaches that were alleged, and went to the surgical one that TGH had now made a specific argument on. So 4 times it's reserved, it's overruled, and now the judge rules. And my husband, when he was a young lawyer, had a judge who was like a kindly mentor to young lawyers. And one of the things he said was, once I've ruled, you have your appellate remedies. There's no case that would say that not renewing arguments that have already been rejected is a waiver of your arguments that you've made 4 times. The law is to the contrary, that there's no requirement for rehearing if you preserved an issue. I want to talk on this, the narrowing of the issues. This is precisely why the summary judgment rule says the motion must state with particularity the grounds. The burden is initially on the movant to show what, is a matter of undisputed fact. Even under the new standard, the movement has to explain which grounds it's raising and why the evidence does not support the claims. And then the plaintiff responds and it presents the evidence. If there's something, so what happened here was Brawley did that, he responded, and then he just out of an abundance of caution, filed Boyko's deposition, filed the deposition of Smith, filed all these depositions. And then on the next hearing, the plaintiff or Tampa General is like, aha, he's narrowed his claims. And again, he said, no, you can't grant summary judgment on a matter that hasn't been raised. And we're trying to withdraw to resolve these claims now that they've been raised and the court's indicated. But the lack of any further development of expert opinions and things like that was because they didn't challenge that. They didn't present an expert of their own. The interrogatory, I would just point out really briefly, if you want to narrow the claims, maybe a request for admission, maybe a summary judgment on that claim. But an interrogatory lay answer is just in conflict with the other evidence, including the interrogatory answers that specifically raised this claim. So that's just a matter of conflicting evidence. The credentialing opinion. Now, this is a new argument attacking the expert's experience. This was an experienced hospital administrator who testified that in his experience, you needed this the person who was experienced in these procedures as part of that credentialing process, and that did not happen here. And again, any failure to further elucidate that was because nobody said he wasn't qualified to offer that opinion. Nobody questioned his qualifications or the ability to make that opinion. The addition to MRI, okay, so it wasn't just Mr. Boyko, Dr. Boyko's, he just came up with this requirement. He, again, experienced as hospital administrator, testified reasonable hospitals have it. Dr. Smith himself gave, it's kind of equivocal testimony that, well, he was aware of this body of opinion. But more importantly, TGH procured this device and the device's instructions are in the record and they say, warning, you need to have pre-surgery imaging. So the evidence was you could mandate that, and well-run hospitals did mandate that. It's within the standard of care and there was no conflicting evidence.
Ms. Norris, thank you.
Yes.
You
Thank
are at
you.
the end of your time. Thank you both. All right, our next case up is Plattner versus Stodgel.